Good afternoon, everybody, and thank you very much for joining us for this final session of Wills Week 2024. It's been another great week of tremendously valuable and insightful information being shared by some excellent resources in our community. So I appreciate both everybody from a lawyer perspective and an advisor perspective who was a part of this week, and for everybody who's attended these sessions. So thank you very much for being part of this. My name is Matt Mandrusiak, and I am the Manager of Philanthropy here with the Edmonton Community Foundation, and I get the pleasure of acting as your host for this afternoon's session. I want to thank once again the amazing group of lawyers, tax professionals. We've had some financial planners as a part of this week's session, all of whom who have volunteered their time to be part of Wills Week and some of the 13 sessions that we've offered both virtually and in person throughout the week. Really, the goal of this week was to inspire and guide people in the proper preparation of your estate plans. These plans include not only a will to protect your family and your business and your assets, but also two additional documents to help you during your lifetime should you temporarily or permanently lose your independence. And we're also hosting this specific session. So if you've ever been appointed or know that you're going to be an executor, this should give you some general information about administering an estate. We understand that the hardships and additional costs that occur when these estate documents are not in place correctly will help you to appreciate the value of getting professional help for you and your loved ones. Edmonton Community Foundation is pleased to provide Wills Week as an important resource for Alberta-based will and estate information. It unites our role as a trusted partner to help create a legacy for our community. Our area of expertise is in endowment funds, contributions that are invested and provide ongoing support to enhance our community during and after our lifetimes. To learn how these funds are affordable options and how they can help save you taxes, please visit our website at ecfoundation.org, which you'll also see right up here. And something new that we've done this year too is we did provide an online session for charitable planning when it comes to both in your lifetime and your estate. So that is currently available for you to view on our website. So please feel free to check that out if you'd like to learn more about those aspects. If you have any questions for our presenter today throughout the presentation, please feel free to use the Q&A box. Please send in your questions at any time throughout the presentation. Though I have talked to Patty before we opened up the room today, she does plan to take questions at the end of the presentation. But if there's something very relevant to what she's speaking to, I may jump in and ask that question during the presentation. So do send those in at any point. I do ask, like we have in any other session, please try and keep those questions somewhat generic. We don't want to get too super specific because the answer is likely to vary, but let's make sure that we are providing as many generic questions as possible so that everybody in on this call can get something of value from the response. Also, as I mentioned to the group while we were waiting before the recording, we do plan on making all of these virtual sessions available to view at any point on our website. Most of those sessions have already been posted. We will have the final few sessions posted likely either this afternoon or early next week. So feel free to check out those resources and share those links with anybody who might be interested in learning a little bit more about wills and estates or estate administration. And finally, before I turn it over and introduce Patty, just a quick reminder that we will have a survey that follows this session. Upon completion, you will be prompted to follow a link and answer a few very, very quick questions. We ask that you please do take the couple of minutes that it takes to run through those questions and provide us with that valuable feedback. We want to make sure that in future presentations of Wills Week, that we are still offering a very valuable service to you. So your input, your feedback really does help us plan for future years. So thank you for that. And now, without further ado, I would like to introduce our presenter for our session this afternoon. We're pleased to be joined by Patty Coe from Bishop and Mackenzie. And Patty has been joining us and presenting at Wills Weeks for many, many years, and we're always happy to have her present. So she gets to wrap up the week this week. So here's a quick bio on Patty before I turn it over. Patty is an associate with Bishop and Mackenzie and practices in the area of estate and commercial litigation, as well as collection, security enforcement, and mortgage foreclosures. With her undergrad degree in commerce and accounting, Patty brings an understanding of business practices and operating challenges to her work. Along with the experience in arbitration proceedings, administrative tribunals, and professional regulatory bodies, Patty has appeared before all levels of court in Alberta. A devoted animal lover, Patty supports various animal welfare organizations. Patty is fluent in Cantonese, plays classical piano, and loves traveling, delicious food, and paper crafting. In her spare time, she enjoys good TV with her fur children. And I am curious to find out what that good TV might be. But for the topic, we'll maybe just focus on what we're here for. So, Patty, I'm going to shut off my mic and my camera. I will be running your slides, but I turn it over to you. So thank you very much for being here.
Thank you, Matt. I'll tell you about the good TV afterwards. Thank you, everyone, for joining us today. Again, my name is Patty Coe. I'm a lawyer with Bishop and Mackenzie. I've been practicing for, I would say, approximately 17 years. And I have primarily my practice is in the area of estate litigation. Although part and parcel to that, I do a fair amount of drafting of wills, estate planning, and administration of estates as well. But I do have a good many war stories about what happens when things go wrong and people start fighting. So, I might share a few of those with you today. So as Matt had introduced, we are here on the Estate Administration 101 session today. And we're hoping today to give you an overview of what being an executor / administrator of an estate entails. Now, I don't expect you to, and nor should you expect to become an expert on this topic and know everything it is that you need to know about this topic after this session. Rather, you probably will walk away with a few more questions than what you started out with. And that's perfectly okay. And in fact, probably one of my goals. I want you to come away with the session knowing a little bit more about what to expect, and also knowing a little bit more as to what potential areas you have to look out for. So you are armed with what you don't know, right? So that you know what you don't know. And as part of that, you will walk away with some questions thinking, well, I need to go figure this out, sort this out, ask this question. If you're working with a lawyer or an accountant or another professional advisor right now, if you're already in an administration situation, you should walk away from this session going, oh, you know what? There was that point right there, that point that I should ask about. I should go away and ask who I need to ask of that. So if you walk away with questions thinking that you have more questions than you started off with, it probably means that, the session went the way that we're hoping it does. Now, before we start, so on to the next slide, please, Matt. Just know that this session I'm providing legal information here. And this does not by any means replace your legal counsel and professional advice, okay? So again, legal information is general in nature. We provide some information about topics that I think are of interest, of what you would like to know in an estate administration situation. But of course, each situation is fact specific. There are nuances to it, circumstances to it that you would be better served with having actual legal advice catered towards your specific circumstance. So the information you hear today is general in nature and is information, again, hoping to prompt some questions for you to go off and ask your various providers and professional advisors some questions of. Now, also, what you should keep in mind is today we are talking about legal information as it pertains to the province of Alberta. each jurisdiction, whether it be from province to province to province or in different countries, every jurisdiction has its own set of laws when it comes to estates, when it comes to wills, when it comes to their processes and procedures in administration. And so if the person who had passed away, and I'm going to be, we generally refer to this person as the deceased, so don't be alarmed by that terminology. But if the deceased was resident outside of Alberta, or if there are assets outside of Alberta, or perhaps there are some interests or beneficiaries and whatnot outside of Alberta, then you may need to seek legal advice in that other jurisdiction simply because the law in Alberta doesn't necessarily apply in that jurisdiction, or the law might actually be completely different. What I can say is there is some variances. For example, if you look in Canada, there is some variances in law as between the different provinces. But of course, all being within Canada, you will see a bit more similarity in approach. If you step outside of Canada, for example, if there are assets in the United States, then the way they practice or deal with a state administration, the laws that affect it can be very, very different. And so, again, be aware that if there are assets outside of this jurisdiction, if that person was residing outside of Alberta, then you very likely will want to seek some legal advice in that other jurisdiction. So with that out of the way, we can start off with the next slide with a bit of terminology. So the first question that we might want to ask is, well, what is an executor? So Matt, if we could, yep, there we go. So that's probably, we'll start with that terminology. So an executor is a person who is appointed in a will, and that person is responsible for administering the estate in accordance with that particular will and with the law. And this person may be a natural person, so much like you and I sitting here today, or can be a corporate trustee. There may be more than one executor, but usually not more than 3. You will need a very good reason to have more than 3 executors. And as Matt had mentioned before, if you are curious about kind of the front end of estate planning, what goes into a will, for example, how it is that you might choose your executors or who should become an executor, there are other sessions that have gone on prior to me with in previous sessions that talk more about estate planning and wills. So you might want to check that out and some of those online sessions there if you're curious about what goes into that. But for the purposes of today, that's who an executor is, someone who is appointed in a will. There is also what we call an administrator, okay? An administrator is similar in function as an executor. This person is also responsible for administering the estate in accordance with the law. The difference is an administrator is appointed when there is no will, when a person dies intestate. That's what we call it. So if you have no will, the person has no will, then an administrator can apply to the court and be appointed by the court to be the person who is responsible, to be the person who administers the estate. Now, who gets to apply? The priority is set out in legislation. And it goes in the order that you would normally expect someone who, for example, had thought about their will and was appointing an executor, who they might appoint. So, for example, a surviving spouse usually has first priority, then children. And then it kind of goes up the line if you have surviving parents, again, depending on, and it kind of goes up the line down from there. And it'll depend on what your circumstances are as to who has priority. So anyone who shows up high in that priority list, the first person applies to be administrator. If someone doesn't want to do it, the next person can apply. That person doesn't want to do it, so forth and whatnot. But that's the difference between an administrator and an executor. The function is essentially the same. You're responsible for administering the estate. However, an executor is appointed by will, by choice of the person who wrote that will, and an administrator is technically appointed by the courts in accordance with priority legislation. And that person wasn't necessarily chosen by the person who has passed away. Now, in Alberta, we call an executor or an administrator a personal representative. So you will also hear that term. And what you will see and hear throughout this session is that I might refer to that role almost interchangeably, either an executor, administrator, or a personal representative, the PR. So if we go to the next slide, let's take a look at the overview, an overview of what the duties of a PR are. And we'll talk about each of these steps a little bit more in detail, but overall, a personal representative steps into the shoes of the deceased. Okay, so they're essentially taking over the role of the person who has passed away and doing whatever it is that they need to do in order to wind down all of the affairs and carry out the wishes of the deceased according to the will or the legislation, and dealing with everything. So everything that the deceased can do, pretty much the personal representative can as well. So think of that person as stepping into the deceased's shoes. Now, in terms of what that actually looks like, here's a list of what you can potentially expect if you're a PR or if you're looking at, who should be your executor. So the PR has the responsibility and the obligation to deal with funeral and burial arrangements. You will hear, and I'm sure everyone here has perhaps come across the term probate, right? Getting probate. We'll talk about that. The PR then gathers all of the assets of the deceased person, of that deceased person's estate. So you gather all of the assets of that particular estate and you pay all of the liabilities. And when all of that is said and done, the PR is also responsible for distributing the estate in accordance with what the will says, if there is one, and the law. Now, along the journey, there are duties to the beneficiaries that the PR has to be cognizant of and has to adhere to. There's duties to account to those beneficiaries for all of the transactions that you may have undertaken as a PR. So again, we'll talk about each of those in turn, but overall, this is kind of what it is that's expected of a PR. Of course, there's a lot of details involved and a lot of actual nitty-gritty of when this actually happens and what it actually looks like. But think of this as a bit of the roadmap. So next slide, we'll turn first to burial and funeral arrangements. Now, a lot of the times when you have a will, the burial or funeral wishes of the deceased can be expressed in the will. Sometimes it is, and sometimes it isn't. Also, the deceased, and it's becoming more and more common, may make arrangements for their own funeral before they actually pass away. So you will see these wishes or these arrangements being made. And ultimately, though, the question of what actually gets done does fall on the personal representative. The PR actually decides at the end of the day. So if there's a wish expressed in the will that either cannot be done or is very impractical for various reasons that it can't be done, then perhaps the PR will make a decision to do it some other way. Or, again, if there's usually when there's prearranged funerals, the PR, especially if it's prepaid for, then of course the PR will try very hard to make use of that particular arrangement as well. But just know the PR is technically the person with the ultimate decision-making power when it comes to burial and funeral arrangements. Now, in reality, I wish I could say it was as clean cut as the PR saying, well, we're just going to do 1, 2, 3, and that's it. Because, what we do know that is when you're making burial and funeral arrangements, that usually comes very close after the passing of the person. And so, of course, you're dealing with many individuals, many people, including usually the PR themselves, who are dealing with grief, dealing with the aftermath of something that just happened quite recently. And there will often be lots of emotions, lots of people involved with their own opinions or perhaps with their own suggestions, and lots of people trying to help. So usually from a practical perspective, these arrangements usually tend to turn out to be either a joint effort with many people assisting, helping, or taking different parts of it, or sometimes the PR isn't even aware that they were appointed under a will and so doesn't ultimately exercise that decision-making power. And that's all okay in the sense that we all know you're often in a gray area, and it doesn't always go very cleanly or in a very good, clean 1, 2, 3 execution type style. So that's usually the reality of it. But under the law, the PR technically gets to decide what happens. Now, when making the decision of what happens, I mean, the PR often takes into consideration the wishes of other family members, other loved ones. The arrangements, you should also keep in mind, should correspond with the means and circumstances of the deceased. So right from this first type of decision, this theme of accountability and duties to beneficiaries, starts coming out. If you have a deceased who is of moderate means, then you do not generally want to spend a very large portion of the estate for the funeral, even if it's an expressed wish of the estate, right? If you have someone who is very well off, then sure, maybe you have a bit leeway there. But again, you want to keep in mind, to the extent that you know that you're the executor, know you're the person making that particular decision, and have the ability to do so, you would want to, as part of your reasonability, type arguments with yourself, you would want to make sure any arrangements should correspond to the best of your knowledge of what the means and circumstances of that person who just passed away is. Now, if we go to the next slide, after burial and funeral arrangements, usually the next set of questions that gets asked, an executor might ask is, look, what about probate? Do I need to get probate? And we hear this term all the time. And so the question is, what is probate, right? So what probate is, technically what it's called is called a grant of probate. And the term probate is very specific to a circumstance where there is a will. We'll talk a little bit in just a second about the circumstances where there isn't a will, but probate is attached to a will. And what probate is essentially an executor will make an application to the court for that grant of probate. That application is now a lot of it is digital or can be digital, but it is essentially a thick stack of questions papers that full of questions about the deceased, about the will, about their potential beneficiaries, where you submit that application to the court. The court looks at the information that has been provided, looks at a copy of the will that has been provided, looks at the various distribution that's provided for in the will and any kind of nuances that go with it. And if all looks to be in order, there are also notices that go out to the potential beneficiaries. Anyone has a potential claim to the estate. And if there are no objections and whatnot, the court will grant this probate. And what you have is essentially a certificate, a grant from the court that says the executor has submitted the necessary documents to the court for review. The court has reviewed that information, and there has been no noted issues, at least not from that kind of level that the court is looking at. And it would appear that this executor is the proper person under the will who should be the personal representative of the estate. And so that certificate basically signals to the rest of the world that that executor, that particular individual has official authority to deal with the estate. That's what a grant of probate is, right? To allow for that executor to tell people that I have that ability to deal with the estate. Now, not all estates actually require probate. Most do, but not all. And it is possible to administer an estate that has a will where there is a named executor and usually when there are no challenges, to administer that estate without a grant of probate. And under our legislation, if an executor chooses to do so, and that's the method that they choose to, there are certain procedures that they also have to follow, such as sending out notices to the potential beneficiaries that are named in the will. But just know that it is possible to do it. But most people in most estates do require a probate. And the reason for that usually has to do with the types of assets that are being held. For example, if you have any kind of real property, so a house, a lot, anything of that sort, a building that's in the deceased's name and solely the deceased's name, then you will need a grant of probate in order to be able to deal with that real property. Land Titles Office, which kind of dictates all the registrations and so forth and whatnot for real property in Alberta, will not deal with any executor who does not have an official grant of probate. Okay, so again, why you need a probate, under which circumstances you would choose to get a probate versus not, usually largely is dictated by the types of assets that you have and the type of estate it is that you have. Similarly, there are lots of institutions or companies that will not deal with an executor unless that executor has that grant of probate. And the reason for that is, I mean, it's fair, right? Because, you know, if someone came to me and said, well, I'm the person that's responsible for dealing with the estate, the first question I would ask is, well, how do I know that, right? And if you just show me the will, I would have questions in my mind as to, well, is this the most recent will? Was there another updated will? How do I know that this is the will that applies? So I will ask you, well, can you show me a grant of probate? Because if you show me a grant of probate, that means you submitted an application to the court where all of those types of questions have been asked already, and there are notices that have gone out. Any challenges where people says something contrary to you know, what perhaps what you say is this will, you know, has already been raised or so forth and whatnot. That grant of probate would give someone like me assurance to say you are the proper person to deal with it, and I don't have to take any guesses. And many companies and institutions out there are in the same boat, right? So if you go to a bank, there's a very good chance that if you have an account with any kind of money in it, that's, you know, every bank has a different threshold. Every branch might have a different threshold. But once you pass that threshold amount, that particular bank will start asking you, well, do you have a grant of probate? And if you don't, they won't let you do anything with the money, won't let, perhaps might not even give you access to information about that particular account. So when you face situations like that, you will need that grant of probate in order to basically say, I have the authority to deal with this particular estate. Now, at the beginning, we said, well, there's a situation, you know, probate only deals with wills. What happens when you don't have a will? Well, then there is what we call a grant of administration that the court can grant. And it is essentially the same thing. The package of information that you provide to the court, the application that you make to the court is extremely similar to what you have in a grant of probate, except there would be no will for the court to reference. And, you know, the information that's filled out would be in accordance, you know, with the legislation rather than, you know, something that's set out in a will. But if there is no will, and there is someone in that priority line to be an administrator wants to apply to administer the estate, they would apply to the court for what we call a grant of administration. And at the end of the day, if that is granted, then you have a certificate, much like the grant of probate, that tells the world that this administrator, this person is the the person responsible for administration of that particular estate. And of course, when it comes to estates without wills, that grant of administration almost is paramount, right? So you don't quite have the option as with the grant of probate as to whether you get it or not, right? Because in a grant of probate situation, there is a will. And so at least you have a piece of paper that says, I'm the person responsible for dealing with this. When you don't have a will, and an administrator wants to establish that they are the person dealing with it, they don't even have that piece of paper, that will. So in most circumstances, when you have an estate that needs to be administered and there is no will, you need to get that grant of probate in order to gain that authority, because there's nothing else you can show anyone to say that you have that authority. So in this situation, I generally refer to either a grant of probate and grant of administration basically as just grants, right? So if you hear me talking about a grant, the probate is the one that applies if you have a will. The administration one is the one that applies if you don't have a will. Now, in Alberta, the court charges a flat fee for either a grant of probate or a grant of administration. And that dollar amount, I believe, tops out at something like $595. They change that amount every few years just to account for a few things. But it doesn't matter, you know, if you have a $500,000 estate or a $50 million estate, when you apply to the court to get that grant of probate or that grant of administration, they will charge you $595 or thereabouts at the maximum for that fee. If the estate is, I think, less than $100,000, it's even less than that dollar amount. So in Alberta, and this is very specific to Alberta, there actually isn't a whole lot of need for people to talk about avoiding probate or avoiding probate fees. It's not a huge concern in Alberta. it is in other jurisdictions, such as, for example, I'll pick on our neighbor, BC. BC has probate fees that are tied as a percentage to the dollar amount or the net assets of the estate. And so in other jurisdictions, people might do estate planning so that their asset base or dollar amount isn't so large when they pass, to avoid a larger probate fee. So that happens in other jurisdictions. I don't necessarily think it's an issue here in Alberta because of that flat fee. Now, what you should be aware of is when I talk about the probate fee, I'm talking about what the courts charge. If you hire, for example, a lawyer or you hire a professional to help you deal with some of the estates, those are fees that are additional to that. And so you would, if you hire a lawyer to, for example, help you get probate, each lawyer has their own fee structure for charging for their services. So you might have additional fees on top of it, but in terms of a strict probate fee that is paid to the courts for granting that probate, that amount is quite set and very minimal in Alberta's case. So that's the probate. So once you get the grant, either grant of probate or grant of administration, then I think your real work starts. And when I say when, it's not necessarily a 1, 2, 3 step. A lot of the times things do happen almost concurrently with each other, and it's hard being an executor. You kind of have you're juggling many balls. But if we're looking at from a very technical perspective, your ability to deal with estates usually start when you get a grant. And so once you get a grant, the next thing that you're doing, if you're remembering our overview map, is that you're gathering all of the assets and paying off all of the liabilities, which sounds, simple enough, right? But again, many, many things come up or can come up in that process, and it might not be as straightforward as you think it is. Again, go back to the concept of the executor stepping into the deceased's shoes. And then think about someone having to step into your shoes right now at this point in your life. How many different things that they would have to deal with in order to gather up all your assets and deal with all of the assets. And not to mention your executor is not you. So they don't actually have the knowledge base that you do when it comes to getting access to those assets. So half of the battle usually is actually figuring out what the assets are, simply because the executor is a third person who doesn't necessarily have perfect knowledge of what your asset base might be. Also, on top of that, we typically think of, there are certain assets that come to mind that we think of as assets, right? We think of a house, a car, some bank accounts, some investment accounts, maybe a second vacation home, and so forth and whatnot. That's our kind of instinctive thoughts or instinctive our gut feeling as to what those assets are. However, there are many other assets that perhaps we haven't thought of, and the type of asset can also dictate what an executor can or cannot do about it, how they gather it, whether they actually gather it, whether it's actually an asset of the estate. So I've named a few here. And again, this is not an exhaustive list of all of the assets that you could possibly think of, but just a few of the more interesting ones that perhaps, as an executor or even like just an individual sitting here today, you might not have thought of in a certain way. So the first one is joint assets. And I'm sure we all know what or have joint assets. For example, the house that you hold with your spouse in joint names, that bank account that you hold jointly with your spouse or even your adult child or your minor child, right? There's lots of different types of joint assets. And what we do have to keep in mind, and again, it depends on the situation, but there are many joint assets that where if the one person dies, so if you're, for example, a house, right, held in jointly, and there's different types of, how you can have joint ownership, but there many types of joint assets allow the asset to go by way of survivor to the surviving ownership interest. So if you have two people in a house and they are what we call joint tenants on title in that house, when one person dies, that person's interest automatically goes to the surviving person, the surviving owner. It actually bypasses the estate. It doesn't belong to the deceased person anymore, and therefore does not belong to the estate anymore. And so that asset doesn't actually belong to the estate. And the executor technically has no say as to what happens with that particular asset. Now, there are circumstances where they kind of get drawn back in, or some challenges are brought. However, technically speaking, a joint asset, if under normal circumstances go by way of survivorship to that other person who survives, doesn't belong to the estate. So, you might look as an executor, go, oh, here's a house, right? That's an asset of the estate. But if you look closely, if that asset was held jointly as a joint tenant with the surviving spouse, technically, no, that house isn't an asset of the estate. It goes by way of survivorship to the spouse. Now, there are exceptions to that, and there are many exceptions to situations like that, and there can be many challenges that are brought in relation to joint assets, such as questions as to whether something was truly a joint asset, or joint assets that are held with between parent and adult children. There's actually a presumption that that joint asset isn't meant to go by way of survivorship, and there's often court challenges that go in relation to that. So there are many, many exceptions, but joint assets again, when we're going through this overview, as an executor or potential executor, what I want you to do is whenever you come across that joint asset, you know that you have to give it a little bit more thought as to whether, or maybe investigation as to whether that joint asset goes by way of survivorship, if there are any challenges that need to be made, or if there will be any challenges that will be brought against a state in relation to that asset. So keep on the lookout for joint assets. Another area or type of asset that you would also want to keep a lookout for are things like those instruments which allow you to designate a beneficiary. So I'm thinking here RSPs, RIFs, TFSAs, right? All of those accounts, when you set it up, will allow for you to designate a beneficiary. Now, if there is a beneficiary that's designated, then again, technically, that when the person dies, the beneficiary gets that asset. Technically, again, it does not belong to the estate. Again, there may be exceptions, but the premise that you start off with and something that you have to look out for is if there's a designated beneficiary on an asset like this, it might not actually belong to the estate. You should do some investigations. Same thing for pension plans. Pension plans, and again, there's many different types of pension plans, ones that are more private in nature and so forth and whatnot, or ones that are not. But let's say someone has worked their entire life and has, pension plans from their company that they worked for and whatnot. And I'm not necessarily talking about, CPP type benefits, but those private pension plans. Again, there is always an ability to designate a beneficiary. And if there's a beneficiary designated, then technically that pension plan, not part of the estate. Pension plans also are like a different creature of their own because they also have their own rules about spouses, about pension partners, and whatnot that can also carve out an exception for a designated beneficiary and where the dollar amounts should go. And again, pension plans is another area, another type of asset that you should look out for, or at least question and do some investigations on if it's involved in a particular estate that you're working on or potentially work on. Same thing with life insurance policies. Life insurance policies also have the ability to designate beneficiaries. If there's a designated beneficiary on there, that life insurance policy plan, that the proceeds of it goes to that designated beneficiary. Again, always exceptions, but something to watch out for. And also one of those areas, one of those assets that a lot of people don't actually think of as assets, right? So if a lot of the times when I just ask an executor, well, what are the assets of the estate? Life insurance policies often get left out because people forget to view them as assets. It's just not typically what we think of as assets. And it isn't until I prompt people that I work with and ask them specifically, well, do you have a life insurance policy? They'll say, oh yeah, of course I have XYZ or whatever it happens to be. And there's also many different types of life insurance products as well. So also, again, in that search for assets, think about life insurance policies as well. Life insurance policies can also come in the form of benefits from your employer, right? So again, it might not be a freestanding life insurance policy that someone had purchased, but the deceased might be entitled to some sort of life insurance type payout as part of their benefit package from their particular employer. So again, in your quest as an executor to look for assets, those are the types of inquiries that you might want to be making, right? Depending on what the circumstances of the deceased are. Another area where many people kind of don't think of right off the bat, although that's changing a bit depending on what generation you're talking to, are digital assets, right? Many of our assets now can be either found in a digital world or accessed through a digital world. We have, I think most of us probably have online banking, and that's probably where most of our banking is conducted. And we might not even have access to physical papers. And if you wanted to get physical papers for a particular bank account, it might actually be more trouble if you don't have an online bank account. There are also, people have bank accounts that are pure only through an online presence, right? Like those banks that don't have storefronts, brick and mortar type locations. I think like Tangerine, for example, is one that I can think of. So you also have to make those inquiries or think about those things as an executor as to how to gather those assets. Also, digital presence, things like social media accounts, TikTok accounts, Instagram, Facebook, those are all technically digital assets. That account, even if you might not necessarily associate any kind of dollar value to it, is still an asset of the estate, right? And so as the executor, you might want to give it some thought. There are also some things, and I remember hearing this story long ago, some digital accounts that you don't think have asset value might actually have some value. An example that we had heard about or was given a few years ago was, if you have a young person who passed away, who, for example, was, I think in that case, like a younger son who was in his 20s, who was a gamer, who had some kind of online game and had an account. And when the executor went about doing their work, they realized that that online account and the avatar, I think it was, and all the associated things that it had with it actually had a dollar value associated with it, because this young man had spent much time and a lot of money playing this game very seriously and had an avatar that was, if you could be sold to others who were invested in this game. And the amount that it could be sold for was something like $100,000, right? Which, it might have never occurred to you unless you did some investigations. So again, as an executor, think about the digital world, think about the digital presence, think about what might be digital assets, and look out for those and do that proper investigation to see what might be out there and what you might have to handle. And then one of the last areas that you might come across in a very complicated area, could be a very complicated area, is if the deceased had any kind of active business interests, right? So if you're dealing with an entrepreneur or dealing with a business owner, or dealing with someone who, had some kind of interest in, and I'm thinking more privately held interests rather than, publicly traded companies, not stocks, but more like shares in, in Alberta, what we think of as mom and pop companies, or, could have very large revenues, but again, is a privately held corporation. Those business interests, you kind of step into their shoes in different ways. And I would strongly recommend the assistance of a good accountant and a good lawyer to help you navigate those and what the obligations, what your rights, what the responsibilities might are. The more active the business, probably the more complex and the more things it is that you would have to deal with. And of course, so what I would caution, and again, this I'm sure was repeated many times by my colleagues and friends in other sessions for estate planning, is if someone has a very active business interest in some active business operations and whatnot, they would need to consider their executor in relation to those business interests quite carefully, because they would want someone with the expertise, with the knowledge. You don't want to just throw someone into it because it can be quite involved and quite complex. So those are assets. Now, of course, you gather all of the assets, and at the same time, you also have to pay off all your liabilities. Again, when it comes to liabilities, there's some things that we are quite familiar with and automatically think of when we think of liabilities, and that's generally debt, right? So we think of credit card debt, lines of credits, car loans, mortgages. All of those have to be dealt with, and all of those can be considered liabilities. But again, there are liabilities that we don't think of right off the bat. And so I wanted to just take a few moments to maybe talk about some of those, point out those areas. So again, so you're familiar, or at least, there's something in your mind, and it plants a seed so that it's potentially something you have to deal with. And so if we go to the next slide, one of those liability areas, and it's a very large one that many practitioners and many people spend the time that they're alive planning for, doing estate planning, is the liability of taxes. Okay. An estate pays taxes, much like how you and I pay taxes today. Upon death, there is what we call the deemed disposition of all assets. So when someone dies, the CRA actually looks at your estate and deems you to have disposed of all of your assets all at once. And it doesn't matter if you didn't actually dispose of it, right? So it doesn't matter if you didn't actually sell the house. It doesn't matter if you didn't actually sell those shares. It doesn't matter if it didn't actually happen in reality. There's a deemed disposition of those assets. And what that tends to trigger for most people are capital gains. And capital gains, of course, are taxable. And so there tends to be a larger tax liability that comes up in terms of dollar amounts when someone passes away, simply because of that deemed disposition. And so a lot of planning, a lot of practitioners specializes in a lot of deceased, particularly when you have a more substantial estate, spend a lot of time pre-death in the estate planning stage, when you're dealing with your wills and when you're dealing with your taxes when you're alive, and how it is that you're structuring your asset base. There's usually a lot of work that goes into that in terms of estate planning, and that's usually what we a large chunk of estate planning. If you're wondering what that estate planning is because an estate pays taxes. So after you die, taxes are still owing. And because of that deemed disposition rule, there's usually a lot of capital gains and whatnot that you have to worry about. And so tax planning is something that you can do before passing, before death. But of course, it's usually inevitable that there's some taxes that are payable. But as an executor, for your purposes, what you have to understand is there are taxes, and there are taxes likely payable, not all the time, but likely there are some taxes payable. And very importantly, always there are some tax filings involved, right? So even if a person doesn't have much of an asset base, and there isn't any kind of complicated capital gains or anything that you have to deal with, at the very least, chances are, if you're dealing with a person who was, for example, working or had any kind of income, right, whether it be CPP or maybe some RSPs that they pulled, or maybe some passive income that they're dealing with. So even if they're older, retired, a person still has income throughout the year. And so when they pass, at the very least, as an executor, you would have a filing for the income that they had earned up until the point of their passing, much like how a natural person would pay income taxes, right? And then on top of it, there are other filings that you might have to worry about. When an estate is kept open for a little bit, it's considered what we call a trust. So there might be some trust filings that you have to do with the CRA. And at the end of the day, there's also a final return that you would also have to file. And there could be a number of different filings in between there. But what you should know as an executor is there are things that you have to deal with when it comes to taxes. Taxes are likely a liability, something that you have to deal with as part of the estate and needs to be paid. And the CRA always has to be paid. So it's one of the liabilities you absolutely have to take care of. If there is that type of liability, you have to be aware that there are tax filings. And the good news, of course, is you don't have to do this all yourself. Nobody expects you to be a tax expert. So much like how in regular life, you and I can go hire an accountant to help us with our taxes and to do our taxes for us, you as an executor can also do so. And I actually strongly recommend that you find the help of an accountant who does and is familiar with estate filings to help you with that, because it's more than what you're, as a regular person, let's say, if you work you're salaried, you have income taxes that you file, and there's, a few forms that you fill out, you might not be comfortable with the various tax filings that are involved with the estate. So an accountant would be very helpful. You can also apply for what we call a clearance certificate from the CRA, which at the end of the day, after you've done all your tax filings, paid all the taxes that the CRA says is owing, and you think that liability is done, you can apply to the CRA for that clearance certificate where they basically tell you, yes, you have filed everything that you needed to based on the information it is that you've provided, you've paid all the taxes that you needed to, and therefore here's a clearance certificate of us telling you, yes, you don't owe us anything more, and it's like the title and suggests it's been cleared. And again, you don't have to, but if that option is available, and usually the more taxes or the more complicated the taxes have been, the recommendation usually is for you to apply for that clearance certificate just for peace of mind as an executor, knowing that nothing more is owing. And so you have that piece as a particular liability. There's also potential claims against the estate as a liability. So what you need to know that is when someone dies, any claims against them, actually, and for that they have as well, carries through for the most part to the estate. So, for example, if let's say the executor is being, well, not the executor, the deceased was being sued and was involved in a lawsuit at the time of his death, that lawsuit likely can be carried forward as against the estate. And so there might be a potential liability there. Or if, for example, the deceased was in the middle of a divorce or a breakup, and there's some matrimonial property type claims that needed to be sorted through, those types of claims carry through the estate. It's to the estate. It just doesn't go away with the deceased's passing. And so those types of claims would then fall on the executor to deal with those claims. Now, again, the executor is not necessarily expected to deal with the claims on their own and super personally. You can hire your professionals, your lawyers, your accountants to help you with those claims. But again, the ultimate job falls on the executor to go and find those advisors and also give those advisors instructions, okay? You will also find that after someone passes away, there might be claims that arise afterwards. And those ones, the ones that I'm thinking of are, for example, if there are challenges to the validity of the will. So if there was a will that was left behind, it could be challenged for various reasons, right? Some of the reasons that it gets challenged for is, maybe someone alleges that that will is not the most current one. Maybe there's another will that they think should apply. Or they might say the will was fraudulent, right? Was not actually signed by the deceased. Or they might say, the deceased didn't have capacity at the time they signed that particular will. And so again, that will should not have any validity. Or they might say the deceased was signing that will under duress, not under free will. So these challenges too come up from time to time. So after a deceased pass away, you might see those challenges. Very frequently, what we will also see or can see are what we call family maintenance and support claims against the estate. I call these FMS claims. And what these are is in our legislation, and again, this is specific to Alberta, although there's similar types of legislation across the provinces, but not necessarily, when you cross country lines, is in Alberta, if a deceased did not adequately provide for what we essentially deem a dependent in their will, or if they didn't have a will period, and that dependent isn't adequately provided for, that dependent can actually bring a claim for essentially a bigger chunk of the estate. And it doesn't matter what the will says. This claim is independent of what's available to that person under the will. And when we think of dependents, the legislation again sets out a category of dependents. They call them family members. And it's very confusing because it is not family members in the conventional sense. It's a very defined term under the legislation. And what they are a surviving spouse, right? Or an adult interdependent partner, what we commonly refer to as common law spouses, minor children, also adult children who are, like 18 to 22, who are still, under the deceased care because they were going to post-secondary education, or adult children who have disabilities and because of that disability is unable to earn a livelihood. And also, if you have, grandchildren, and that particular deceased has been the care provider, primary care provider for those grandchildren for a certain period of time, that those grandchildren can also be considered those dependents or family members. And if the will or the estate generally does not provide adequately for those family members, they could bring that claim. So you do see those FMS claims against the estate, and it's not uncommon. Now, and if we if you think back to that little conversation we had about joint assets, there are also challenges that can be brought in respect of assets that are held jointly. One of the more common ones that we see are assets that are held between a parent and an adult child. And in law, the presumption is, so for example, if mom had, put on a bank account and put on an adult child's, her daughter's, her 36-year-old daughter's name onto her bank account, and it's held jointly. Well, when mom passes away, technically there might be a survivorship clause in the banking agreement that says it passes to adult child. However, in the law, there's actually a presumption that says the complete opposite. There's a presumption that says if there is an asset held jointly with an adult child, between a parent and adult child, the presumption is actually that, unless there's a contrary indication, that the parent didn't actually intend to gift that asset over to the adult child despite it being held jointly. And that evolved. The reason for that is it's because parents often put children on title or jointly with an asset as a matter of convenience. And they don't think about the consequences of what the survivorship clause might be. And so the law has kind of evolved to put a presumption down, partly to protect parents, and particularly elderly parents, from having kind of their intentions construed as it's giving it to the children. Oftentimes, like if you think about it, there's lots of elderly parents who, for example, don't want to go to a bank and don't want to deal with the banks. And so their solution to it is to have their adult children help them deal with the banks. And they find it very cumbersome to always, have to give instructions or have to tell the bank that the child can do it. So their solution to that is to say, hey, I'm going to put this child's name on my bank account. Therefore, they're on the bank account. They can go and write all the checks I want. They can go help me pay this. They can, help me move some money. They can do bank drafts, whatever it happens to be. But at the end of the day, that parent might not necessarily have intended for that child to actually have all of that money in the bank account, right? Especially if there's other children involved. That parent still views that money as theirs, and they have assumed that it would be dealt with in accordance with their will, which might split for example, the proceeds equally between all of their adult children. And so there's actually that presumption there, and there are some lawsuits that arise from that, with assets that are being held jointly, on people either challenging it, saying, well, no, that person shouldn't get it, or perhaps asserting a claim to it the opposite way, right? So again, those types of assets and those types of liabilities, it's something that you have to be aware of or cognizant of. I'm not saying it applies necessarily all the time. And it's not necessarily that like a pop up in an estate that you're administering, but it could, right? So again, something to keep in the back of your mind, maybe some questions to ask, or maybe just, here are some things that I have to look out for. Now, in terms of your duties as an executor, we've kind of outlined what it is that generally you're expected to do in terms of steps. Gathering all of those assets, dealing with all of those liabilities. Throughout your execution of all of those types of actions or things that you have to do, what you have to keep in mind is that as an executor, you have a duty to those beneficiaries. So lots of times executors might ask me, well, my duty is to administer it according to the will or according to the legislation, which is true, right? That is not wrong. But you don't just blindly look at, for example, the wishes of the executor and say there's only one way to do it. What you also have to keep in mind is at the end of the day, what you generally are expected to do is maximize the dollar amount that's left over for those beneficiaries. You have a duty to do basically the best under reasonable circumstances, or what could be reasonably expected of you, to essentially have the highest residual, the leftover amount after you've gathered all of those assets and after you've paid off all of the liabilities, to distribute to the beneficiary. So you always have to keep that in the back of your mind. And I'll use an extreme example, right? So let's say there's a house. So you've determined that there is a house. That's the asset. Let's say it's only in the deceased's name. So you go and get your grant of probate, and you don't have to worry about it not being an estate asset. It's an estate asset. So there's the house. Well, now in order to basically distribute to the beneficiaries, usually what you do is you sell the house, turn it into cash, and then distribute it according to the will or what the legislation says. Well, your obligation when it comes to selling that house, you can't just like look at the house and go, well, you know what? I think it's worth $10,000. We're just going to sell it for $10,000 to the first buyer who comes around, right? Who offers me 10,000. The expectation for you would be to take reasonable steps to maximize, to determine the true value of that house, and also to maximize the return for it, right? So what a normal person would do, what you and I would do if we were looking to sell the house, hire a realtor, get an appraisal, put the house up for sale for an amount that, for example, the realtor suggests. And then when offers come in, you decide on which offer is has the highest amount or the most favorable conditions, and then you sell the house under according to those situations. You don't just go, hey, I'm going to sell the house for whatever amount that pops into my mind, or I can get rid of it quickly. Here, $5, take it. Right? That's not what you would do. But I recognize that's an extreme example, but just to keep in the back of your mind, your duty is also to the beneficiaries. So you cannot just think of it in a vacuum. You have to understand that you're holding something in trust. And so you should do your best under the reasonable circumstances to maximize that amount that comes back. At the end of the day, you do have to account for all of the transactions that you've undertaken, right? So this is what we call an accounting. What you're generally you have to do at the end of the day is show basically a reconciliation to the beneficiaries and show them here are all the assets at the beginning, here are all the liabilities at the beginning, and then here are all the transactions that took place, right? I sold the house. Here's the dollar amount that we got back. Here's how much we paid commission for the realtor. Here's how much property taxes we had to pay. At the end of the day, here are the net proceeds. And this is the $500,000 that's in the bank account. And this is what we have to work with. This is how we're going to distribute it. In the meantime, we've incurred some accounting fees. We've incurred legal fees. We've had to pay XYZ taxes. We've had some miscellaneous expenses here. And so at the end of the day, maybe there is $400,000 left over. And then you say, and here is the $400,000 that we have left to work with. So that's an accounting. You take the beginning opening amounts, you show what has come in, what has gone out, you document that, and then you show them at the end of the day what that dollar amount is left, and that's what's available to distribute to the beneficiaries for the most part, right? And so you ultimately have to account. And when you are at the stage where you've gathered all of the assets and you've paid off all of the liabilities, and all you have is just what is available to the beneficiaries, you might then start looking at that distribution. And you will need to provide that accounting to the beneficiaries before the distribution. In good practices, you will want the beneficiaries to agree with all of those things, with the accounting and what it is that you've done, and sign a release saying, yep, we agree, you did a good job. We're not going to, say you didn't want to do what it is that you were supposed to. And then you have distribution. And so keep in mind, whenever the whole time that you're being an executor and carrying out all of these functions, remember your duty to the beneficiaries, and remember you have to, at the end of the day, account to those beneficiaries. And so as good practice, please keep good supporting documentation. Keep your receipts, keep those bank accounts, keep a log of what it is that you've done, the time that you've spent on the task, what task it is that you particularly carried out. Seek professional advice when needed. Like I mentioned several times, you're not expected to do this in a vacuum. You're not expected to be perfect. You're not expected to to be able to have all that knowledge and know-how and skill. So you can hire lawyers, you can hire accountants, you can hire financial advisors for the most part to get the help it is that you're required to carry out those tasks. And I would always advise communication with beneficiaries to the extent that you can is always a good idea throughout the administration of the estate. Because the more information other people have and not radio silence, the more likely they are to understand what it is that you're doing, to understand that you are actually doing something, and that none of their suspicions and whatnot arise. And again, it kind of depends on your relationship with the beneficiaries, right? Like if the other beneficiaries are siblings that you get along with very well, you might by nature just have conversations with them all the time and they know what's going on. Sometimes if they're a bit more removed in terms of relationships, you might have to put up more formal communication. So nobody's saying you have to give like a weekly update, but communications that you can manage reasonably, I generally find is very helpful to the process, so that no one's calling you up and thinking like that you're doing nothing and accusing you of something that's not true, and that making the relationship more difficult. So consider those communications with beneficiaries. Now, there are also other considerations, things that I get asked about in terms of being an executor. And those things are, again, I put it on here and we'll have some time for some questions at the end, but things like, well, what's the timeline? Like how quickly should I basically be expected to administer the estate? Things like, what is my personal liability and executor's fees? So timelines wise, I'm sure a few of you might have been told that there's an executor's year, right? That you're expected to administer an estate within a year. There is that term, and if you can administer an estate within a year, I would say good for you. Good, go for it. Oftentimes, it's also not unusual to see an estate go over that time limit. And it could be for various reasons, right? Sometimes it's for reasons that are completely outside of your control. For example, during COVID, that period of time, all of our institutions were extremely slow, right? Including our court system. So it actually wasn't unusual at that time that if we submitted, as a law firm, if I submitted a grant of probate, it could take 8 or 9 months before the courts came back to me with a grant. And that was during COVID. So it was a circumstance that was completely outside of our control. Now, much more reasonable. It can be 4 weeks, 2 months, maybe 3 months, depending on the type of estate you are or where it is that it's located, which center it's in. So sometimes things are taken out of your control. If you have any kind of challenges, court challenges to the estate, or if you have an FMS claim, those joint asset liability claims, it's definitely going to take longer than a year because, again, then you would be in the litigation phase of stuff. And the litigation is not fast. I assure you, it could take a very long time. So depending on the type of estate, it actually can take longer than a year. But if you have a straightforward estate, in today's time where there might be, a house that's held jointly with a surviving spouse with 2, bank accounts, one savings, one checking, and a car, I would say, yes, you could very likely complete that administration within a year, right? But again, it depends on the circumstances. Now, when it comes to executor's fee, at the end of the process, so when you're at the point of where you're ready to distribute, and all the assets have been gathered, all the liabilities have been paid, and you're now looking at distribution. An executor generally can ask for an executor's fee because, of course, this was a lot of hard work. You put in a lot of time, a lot of effort. You've probably incurred some expenses of your own, which can be reimbursed for the most part. But you're unless the will says something to the contrary, or if there's some exceptional circumstances, you can say, well, I did work, and so I should be compensated for it. You can ask for an executor's fee. And the beneficiaries can just agree to your executor's fees, or sometimes if the beneficiaries don't agree to either your proposed fees or the accounting that you provided, you can also go to court and basically make an application to say, hey, court, can you decide what is reasonable in these circumstances? Now, normally there's a range, right? So for executor's fees, you can look at, I would say, anywhere between 1% and 5% of the, and some people go by gross value of the estate, some people go by net value of the estate. I will generally tell my executors that 2.5%, somewhere in the middle, is very reasonable. If you go higher than that, you better be like, it better be in a state that involves way more work than what you would generally expect. So for example, if there were some many complicated challenges in court, or if there were business interests that took a very long time and was very difficult to wind down or to deal with or handle. But again, it's very circumstantial, depends on the situation, depends on what the beneficiaries will agree to, depends what it is that you had to deal with. Sometimes it depends on what the will has to say. Sometimes, like some wills will specify what the executor's fees are, or what the ceiling is, or that someone's entitled to more executor's fee, whatever it happens to be, right? And sometimes it's dictated by, if, for example, you will remember that an executor can actually be a corporate trustee. So if you had gone the way, if the deceased had gone the way of hiring a corporate executor and had put a corporate executor in their will, those corporate executors would have fee schedules that have been agreed upon beforehand, right? So again, all circumstantial, depends on the situation, but there is that concept of executor's fees. Most executors can ask for it. How much is a question that's dependent on, again, a number of different factors. And then that last piece, that personal liability, I have lots of executors asking me, well, I'm concerned about this. If I take this on, does it mean I have any kind of personal liability? And my answer generally is you step into the deceased's shoes. You don't take on their assets. So, their assets don't technically belong to you, even though you might be holding it for safekeeping, nor do you take on their liability. So just because you're an executor doesn't mean you're personally liable for the debts of that deceased. However, if you step outside of a role and go and tell the bank you'll pay for it personally, then you might take on personal liability. And so what I say to my executors is you don't have personal liability unless you do something that takes on that personal liability, or you do something that is inappropriate or negligent, and takes you outside of your duties as an executor, and you either do it something very wrong, or you're doing something that an executor shouldn't be doing, there is no personal liability. So again, I'll take as an example of personal liability if you're veering outside of your roles, is that duty to the executors. Let's take that house for an example again, right? So if you go and take a house and sell it for $5 without making any inquiries as to what its actual value is, what it might be able to get on the market. You just said, I want to get rid of it. Here's $5. Here's $5 to the beneficiaries. Well, the beneficiaries at that point might look to you and go, well, you failed massively in that duty as an executor, and that house was worth $500,000. You sold it for $5. I'm going to sue you personally to give us back essentially $500,000. That could happen. But you would, again, have to be acting in a way that is in breach of your duties and wildly off course, basically, right? So if you do everything that you're supposed to do, generally speaking, you shouldn't be taking on personal liability. So when it comes to my final thoughts, and we have a little bit of time for some questions, what I want you to take away a little bit too is, as you can tell throughout, there is importance in estate planning. So what you do on the front end before you die, when you do your estate planning and your wills and whatnot, does have bearing on what happens afterwards, right? So estate planning, I think, is important, can be key sometimes to minimizing conflict at the flip end, or any kind of challenges that might come around. If something that you can take care of on the front end, might be helpful on the back end. So something to think about for those who are looking at their own estates, and whether they should do some planning. As the person who's sitting in, if you're alive and you're looking at appointing a personal representative, an executor, make sure that executor actually has the capacity, the know-how, and the desire to take it on. As you probably took away from the session, this can be a lot of work. It is a lot of work. Being an executor is a huge amount of work. And so you want to make sure that the person that is appointed has the ability to do it. And that might just come in the form of time or desire. And if possible, if you know you're going to be appointed as an executor, or you're appointing an executor, it's very helpful to have ongoing discussions before you die, right? To tell the executor, or as the potential executor asks those questions, like, what are your assets? Where are your assets? What kind of assets should I be expected to deal with? What kind of liabilities do you have? Like a simple question as much as like, hey, what bank do you bank with? Would be very helpful if you know nothing about that person's particular estate or what their financial situation or asset base is, right? And you'll be constantly surprised by the answers that you get. You think, like, even if this is your parent or you're dealing with a child, what you think you know often, I guarantee you, once you've had that conversation, is not actually the full picture. So those are my last thoughts that I want to leave everyone with. And I think so. Thank you very much for listening to me talk for quite a long time. And I'll turn it over to Matt right now, maybe as our moderator. If there are any questions, I'm happy to try to answer them now.
Yeah, thank you, Patty. That was great. As I mentioned during the introduction, I know you've been doing this for many, many years for us, and every year you continue to provide terrific information. So I really appreciate the fact that you were willing to volunteer your time yet again here today. We do have some questions now. They're coming in pretty quickly into the chat. So I am going to, I'll ask an easy one right off the bat. Are you a litigation lawyer?
I am. That's what I would consider my primary vocation.
There you go. Perfect. So that's a quick answer. We can check that one off pretty quick.
I like those questions.
Those are always good ones. Here we go. Is there a resource you can recommend that one can use to summarize their assets and their liabilities so that when they pass away, there's a summary document that an executor can go to?
Does the ECF have something similar, Matt? Or was there a package that the ECF has?
You may be right. If you may be jogging my memory here, there might have been something from an agency that we were provided a little while ago. I can try and dig that up. If we do have something that might fit this answer, I'm happy to email it because we have emails for registrants to watch this session. I'm happy to email it to the group after the fact, but I'll take a look.
Yeah. And outside of that, I have to be honest, I don't have a set resource. What my firm usually does, like what I usually do when I meet with clients for wills or even in a state situation when they first come to us and say, you know, I'm an executor, I have what I call a wills questionnaire or an estate questionnaire that goes through a whole bunch of questions. Part of is, you know, about the deceased or about the person who's making the will. But also like questions about what the assets are. So we'll have very pointed questions about, hey, do you have a pension plan? Do you have an XYZ? And so if you find that helpful, by all means, please feel free to email me afterwards, like at my that email address. I think was somewhere around here. If not, I think it's on the ECF website. Feel free to email me, and I would be happy to provide that wills questionnaire, for example, that I send to people, or that estate questionnaire. So it gives you, like, you can actually help, you could fill it out, right, with your executor, potential executor, or with the person that's who you might be administering the estate for. So I'll be happy to send that along.
Perfect. Thank you very much. And if there is, I'll just piggyback on that if people do have specific questions or are looking for specific resources and can't find Patty's email anywhere, do email us at ecfoundation.org, or you can find any of our contact info there. We'll be able to make sure you're in the right place.
And what I always tell people, like the people who are doing the wills, is if nothing else, write down who all your advisors are, right? So if you have a particular accountant, lawyer, financial advisor, banker that you work with, write them all of their names down, where they are, what their contact information is. And at the very least, then your executor just call these people up and go, okay, what bank accounts am I working with? So at the very least, do that.
Perfect. A question here around hiring a company, like a trust company, to act as PR. How does one go about finding such a company? And how does one figure out whether that particular company might be trustworthy and will do a good job?
So every major bank in Alberta has a trust branch. They have different names. So you might see, like, and I'm not advertising for any particular branch, but for example, you might have TD Wealth, you might have Scotia Wealth. ATB has their trust branch, CWB has their trust branch, Service has their trust branch. So if the bank that you bank with, if you go ask that question of them, who is your trust branch, they'll have a slightly variation on their name, but those are all basically companies, they are companies that take on trust files. And what that means is they'll also take on being a corporate executor. Now, they might have different criteria as to what files they may be willing to take on, but it can't hurt for you if that's what you're looking at. Make an appointment with them, right? Like as you would with any banking institution. Have a conversation with one of their representatives, and go from there as to whether you, for example, your type of estate qualifies. And I would say any of those companies clearly being, associated with banks would probably give you a good comfort level. And again, if you need specific individuals that you want to be pointed to, I mean, I do work with some day in and day out. So again, if you want to email me some, particular interest that you might have, I'll be able to help out too. But definitely, all banks have a trust branch. And that would usually be the first. I would recommend that you go there first to see what the options are.
And I suppose it could be very much like finding a lawyer to write your will, where you're looking for options, finding the one that fits your needs the best and gives you the best sort of gut feeling when it comes to something like that.
They're all, they're all good. That's what they do for a living, right? That's their job. But it might be finding one that's suitable for you, right? Like someone that it might be right down to the individual who it is that you're most comfortable with. Yeah.
Perfect. Okay, a couple of questions around releases here. How can a beneficiary provide the executor with a release letter as proof of what they need to follow?
So usually what happens is when you get to the point of distribution where you want to make a distribution of money, what my usual practice is we have the executor put together the accounting. So again, that could also be with our help or with an accountant's help. You put together the accounting. And there's a form that we use usually. There's a set form that the courts, there is actually in the rules that provide for a form. You don't always have to use that form. Sometimes we vary it depending on the circumstances. And you send it to the beneficiaries and say, here's the accounting. Here is, all the numbers. Here's what we propose to distribute. And you break it down and say, here's my executor's fee. This is what I propose to take. If you're agreeable to such, please sign this and get this back to us, and you make arrangements for that. And then, once everyone gets it back to you, you might say, okay, I'm comfortable. We're going to go make that distribution. And other times, like I said, you might have to make a court application if not everyone agrees, for a court to kind of give you some direction as to what's reasonable.
Okay. And so following on some of the accounting and things like that we're talking about here, can beneficiaries require the executor to provide a full accounting to them before the attempt to file the final CRA before the final CRA clearance certificate?
Those are technically like two separate processes. So the CRA certificate talks purely about taxes, right? And so I see that as a different stream versus an accounting, whereas the accounting talks about the totality of the estate. So I don't think it's necessarily, from my view, as to why one needs to be tied to the other. And clearance certificates, honestly, can take a while to get back. So usually my practice is as soon as we can go apply for it, let's do it, right? Because it could be like months before the CRA gets back to us. But of course, there might be specific circumstances in your situation why you might want to do that. And so if you're working with a lawyer, ask that question of them as to what those risks are, what the recommendation might be.
Okay, so beyond the clearance certificate piece of it, what can beneficiaries do if they are not satisfied with the executor's estate accounting?
Well, I usually start off with, and I do ask for, I do act for, from time to time, beneficiaries who aren't happy. It kind of goes both ways. Usually my first step is you ask for more information, right? Like you ask first and say, here is what I think the deficiencies are. Maybe you need supporting documentation. Maybe you don't know why it costs $500 a month for haircuts. I have no idea, right? But you ask for that information first. And if it's not forthcoming or it doesn't give you the answers that you want and doesn't clarify it, or it gives you a bunch of answers where you get the accounting and you're like, well, this is just wrong. I don't know. Again, I basically dispute the money that was spent. Then you might look at litigation or a court application to either compel more information or essentially to go after the executor personally.
Okay. Thank you. There's a couple questions here that are relatively specific, so I'm going to try and pare these down and make them a little bit more generic. But essentially, it seems to me, at least, that these two questions are asking something similar. Can an estate, or how can an estate be closed if there are any outstanding balances or liabilities owing?
The answer is you can't. So once you started administering, um, an estate is open until all of those issues are technically dealt with. Like that's the way I view estates. So until all assets have been gathered and all liabilities have been paid, you wouldn't consider that estate to technically be done and fully administered, and that's just kind of the view of it. But of course, uh, you know, again, there are exceptions and circumstances as to how you might deal with a particular fact scenario. But that estate, I think, if there's something owing or if there's something outstanding, I would still consider it open, is kind of the general viewpoint of it.
Okay, thank you. This leads to what is now the final question, and again, a little bit more specific and maybe not necessarily to do with the administration of an estate, but perhaps something that you have seen in your experience. What might be the best way for someone to speak with their adult children or somebody close to them to help with banking duties without actually having to activate the power of attorney?
I would say this is a bit of a gray area, right? So being very cognizant of what I just said about, some people's solution to this is to put their adult child on as like a joint account holder. I don't necessarily recommend that all the time, just because of the complications that can arise. But it is sometimes what parents choose to do. And if that's what they think is the best choice, then sometimes that's what happens. Now, what I would suggest is if someone does choose to put on an adult child as a joint something, right, purely for convenience purposes, is to make it clear, then write it down and say what your intentions are, right? So even when I make wills for clients, they might tell me, oh, I have a joint bank account with my daughter. And then I will ask them, well, are you intending that money to go to the daughter when you pass? And they're like, oh, no, it's supposed to be like, that's my money. It's supposed to be distributed according to my will. So I will put a clause in there that says, and any bank accounts that I held jointly with my adult children, the money in there is intended to not be hers, not go by way of survivorship and go into the will. Or conversely, if the intention is to go to the adult daughter, I would also put that intention in and say, look, it's meant to go to her when I pass.
Right.
So sometimes that's the solution. Other times it really is, what your relationship with, for example, the bankers, right? What authorizations you might be able to give to the bankers, the bank in general beforehand as to how it is that you can help your parents do banking duties. Sometimes it might be as simple as, again, like, being able to help them online, right? From the comfort of your home, being able to help them online. Depending on what the issue is with the adult, like, because power of attorneys sometimes can be triggered, like not triggered, but can be in effect when, the parent is perfectly fine of sound mind, they just don't want to do it. Sometimes it's because there's some cognitive decline or because capacity is slipping. So sometimes there are things in between personal, like a whole power of attorney being triggered, and maybe there's some alternate decision-making tools that you might be able to utilize. So there's a little bit of wiggle room in there, but a lot of the times it's more practical, life-based solutions, depending on what it is that the situation actually is.
Perfect. Well, thank you for that. I hope that helps clarify that scenario. And since that looks like it's cleared our Q&A box, and we're right at sort of 2:30 here, so perfect, right on time. And knowing that this is a Thanksgiving long weekend coming up, I'm sure some of us, including you, Patty, have some weekend plans that we were talking about. So I want to thank you very much for being a part of Wills Week yet again and lending your time and expertise to this session. So on behalf of my colleagues at ECF and the folks who tuned in today, thank you very much for being a part of this. I'd also like to thank everybody who was on the call today and participated in any session throughout this week. We really appreciate the fact that you're coming out and spending time with us and learning about these important topics. So thank you for being part of Wills Week and for providing your feedback. And I'll remind you one last time before we say goodbye, and I wish you a happy Thanksgiving. Please do stick around for a couple of minutes post-session here to answer that survey. Provide us with your valuable feedback. We want to make sure that when we put put this together for next year, we're putting something that's worthwhile out into the public. So with that, for anybody who's looking for additional resources, if you need to get in touch with Patty, if you'd like to see any of the recordings that we've already posted on our website, please visit ecfoundation.org. Look at our Wills Week initiative. You'll find all the resources that you'll need right there. And then don't hesitate to reach out to any of us, myself, any of my colleagues at ECF, if there's anything that we can do to provide additional resource to you. So before I say goodbye, Patty, any closing thoughts from you?
I was just going to say thank you, Matt, for moderating and hosting today. Thank you, ECF, for putting on Wills Week every year, and sometimes a State Administration Week too. It's a giant effort on your part as well. So thank you very much. Thank you everyone for attending, and happy Thanksgiving.
Thank you, Patty. It's our pleasure. And just like you, I wish everybody a very happy Thanksgiving. Take care, everyone.
Well.